Bloomberg Quint, the Supreme Court today witnessed high drama in a matter pertaining to alleged judicial corruption. The events are related to a recent case in which a retired Orissa High Court judge and a few others were arrested by the CBI allegedly for conspiring to settle in the Supreme Court a case of a Lucknow-based medical institute that was barred by the government from admitting students. Now, in this connection, well-known lawyer Prashant Bhushan filed a writ with the Supreme Court asking for an SIT-led investigation, a special team to investigate this matter of corruption in medical colleges and the allegations made by that Orissa High Court judge that he could settle a matter in the Supreme Court. All this week, that writ petition has been in and out of several courtrooms and culminated today in an unprecedented flare-up. I spoke to Prashant Bhushan to find out exactly what went on.
The CBI FIR of 19 September essentially says that there was a conspiracy planning and preparation to bribe judges of the Supreme Court who were dealing with this medical college case. And in fact, the presiding judge who had dealt with it throughout was the present Chief Justice of India. Now, when we came to know about this FIR and the arrests, etc., we felt that it would be very improper to leave the investigation in the hands of the CBI, which is still essentially a government-controlled agency, a caged parrot, as the Supreme Court had said, and that this investigation needs to be in the hands of a totally independent SIT, which should be headed by some former judge of the Supreme Court and monitored by the Supreme Court in order to ensure a thorough, independent and deep investigation, but without giving any opportunity to the government to use this case to undermine the independence of the judiciary. So we filed this petition seeking this prayer. This was mentioned before court number 2 day before yesterday, because mentioning for urgent listing is usually done before the Chief Justice, but the Chief Justice on this day was in a constitution bench, and therefore urgent mentioning was before court number 2. Even otherwise, the Chief Justice ought not to have been hearing this matter either on the judicial or administrative side, since he would be within the scope of the investigation. So we mentioned it before court number 2, and the court number 2 directed that this matter be listed on Friday before court number 2. But during lunchtime, we received information that the Chief Justice has passed some order to list it before some other bench, court numbers, which we later came to know was court number 6. Yesterday, another petition was filed by Ms. Kamini Jaiswal. Again, the matter was mentioned for urgent listing and hearing before court number 2, and court number 2 directed the matter to be heard before itself at 12:45 yesterday. And at 12:45 during the hearing, some registrar apparently hurriedly brought some note. We understand that there was a constitution bench in court number 1, but that constitution bench suddenly rose at 12 o'clock, and at 12:45 some registrar hurriedly brought a note to the court number 2, effectively saying that the Chief Justice had passed some order saying that this matter should be sent to the Chief Justice for listing, etc., for either hearing or listing. In any case, the Justice Chalmeshwar took that note on board, made it a part of the order, but passed an order saying that this is an extraordinary matter involving the integrity and independence of the judiciary, and therefore it should be placed before a bench of the 5 senior-most judges of the Supreme Court on Monday. Now, this happened yesterday, but then today, when our matter, the campaign for judicial accountability matter, was listed before court number 6, I told the court that this order has been passed in a similar matter to list it before the senior-most 5 judges on Monday, and that this should be connected and tagged along with that. Now, we thought that he had passed this order of tagging this case, that the court had passed that order, but at 2:45 p.m. I received a call from the registry saying that I had been called to court number 1 because a 7-judge bench had been constituted to hear this matter at 3 p.m. Now, when I went to court number 1, I found that there were 7 chairs, but then 2 chairs were hurriedly removed, and there was eventually a bench of 5 judges headed by the Chief Justice and none of the other senior judges of the Supreme Court, and 4 other relatively junior judges to hear this matter. During the hearing, immediately after the hearing began, I told the Chief Justice that, look, this is an extraordinary way in which this matter is being listed, and in any case, he should recuse himself from this case because he should not deal with it either on the judicial side, certainly not on the judicial side, nor even on the administrative side. But ignoring that, he kept asking other lawyers who were sort of random onlookers there to say what they feel, etc. And many of the lawyers there, it kind of became a rather unseemly spectacle. Many of these lawyers started saying that the court number 2 had no jurisdiction, no authority to pass such an order, no authority to list it before the bench of the senior most 5 judges, etc., etc. Thereafter, I tried several times to get a hearing, but I wanted to point out that, look, what's wrong with the 5 senior most judges of the Supreme Court hearing this matter? Why should you oppose that? Why should you try to undermine this? Because, and in a matter where you yourself are concerned, it would look most improper if you try and undermine that order and try and fix the bench yourself. But he did not give me any opportunity for saying anything. After trying 4 or 5 times, I just left the court in a huff and told the court that they could then pass whatever order they want. And thereafter, after I left, apparently an order was passed, effectively saying that all orders passed by any other bench fixing any case before any particular bench are set at naught, and that both these cases would apparently come up after 2 weeks before a bench nominated by the Chief Justice. So far, that order has not yet been uploaded on the internet, but this is what some of the people who were there in court told me, that this is the order.
So if I may ask you some more questions about today's event. Mr. Bhushan, were you asked to leave the court or escorted out? Because there was some reporting that suggested that you were asked to leave the court, and there was some reporting that suggested that you were so upset that you in fact walked out yourself. I just wanted to set the record straight on that.
No, I walked out myself because after I found that the Chief Justice was not at all willing to hear me, and he was only interested in hearing some other random lawyers who had nothing to do with this case, then I said that there is no point in my remaining here and that they could pass whatever order that they wanted in my absence, so I left.
Mr. Bhushan, also if you could explain.
But when I was leaving, I was sought to be prevented.
Okay.
I was sought to be prevented from leaving by some of these sort of rowdy lawyers, but thereafter I was kind of escorted out by the security people there.
Okay, so if you could also explain to us, why is it that you were asking for the Chief Justice to be recused or to recuse himself from this matter? After all, the administration of the court, the decision on which bench should hear what, effectively lies with him. So what was the basis for your request?
Yes, but that rule does not apply to a case where the Chief Justice is himself involved or where he has a conflict of interest. Now, this was a case where the CBI's FIR and investigation is supposed to also be around whether the FIR says that preparations were made, conspiracy was hatched to bribe the Chief Justice, whether that conspiracy involved the Chief Justice himself or not. It doesn't say Chief Justice, it says the judges of the apex court dealing with this matter, and the Chief Justice had been dealing with this matter. Whether he was involved in this or not would be a matter for investigation. I hope and wish that he is not involved in this matter, because such a finding would seriously undermine public confidence in the Supreme Court, etc. But in any case, if the investigation is also going to be around his role in this matter, and there were 2 middlemen, one retired judge of Odisha, one other middleman who had been brought from Odisha for bribing in this case, clearly it was not proper for the Chief Justice to have dealt with this matter, certainly not in his judicial capacity and also not in his administrative capacity by way of fixing or deciding benches.
The Chief Justice apparently in court today, and I'm relying on some reports for this, sir, because I myself was not there, but he said that the decision on determining which bench lies entirely with him, and that was his explanation for why he had not allowed for court number 2 to hear your matter, and subsequently also not allowed for court number 6 to hear your matter. Did you find that something that you did not agree with? That's question number 1. And 2, can you explain to us the peculiarity of there originally being a 7-judge bench and then that being pared down to a 5-judge bench? You know, for commoners like us, we don't fully understand why would that be a material decision or a material situation.
So, you see, normally it is true that the Chief Justice is the master of roles and he decides which bench will hear any matter. But that does not apply to a case where the Chief Justice himself is involved, where he has a direct conflict of interest in the matter. In that case, the principle of recusal applies. He should recuse himself and allow the next judge in line of seniority to decide this, as to which bench should hear this matter, and allow that judge to decide the bench. Besides, what had that bench done? It had only said that the matter, this is an extraordinary matter of great importance and great sensitivity, and therefore it should be heard by a bench of 5 senior-most judges of the Supreme Court, as had been done in the case of Justice Karnan. But instead of allowing that, heaven and earth was moved by the Chief Justice to undermine that order and ensure that that order is undercut, and he himself fixes the bench which will hear this matter. I find this very extraordinary and very disturbing. The other question that you have asked is the significance of 7 judges. You see, they had notified 7 judges, which included the judges of court number 6 today, Justice Sikri and Justice Bhushan, but eventually they did not sit and their chairs were removed and only 5 judges sat to hear this case. I don't know why they did not sit, I have no idea. And I also find it a little strange that a notification is put up saying a bench of 7 judges and thereafter only 5 judges sit and they proceed to hear this case. But I mean, all kinds of strange things have happened in this case, which are extraordinary.
Mr. Bhushan, just to go back to the first part of your answer, I know you've explained to us on the grounds of which you sought the recusal of the Chief Justice of India, but to be fair, nothing within the Orissa retired High Court judge matter, if I may refer to it that way, suggests or points any fingers at a particular judge. When they were making promises to medical colleges saying, and alleged promises to medical colleges, alleging that they had some way of being able to get favorable judgments from the Supreme Court or whatever it is that they said, that was discovered and that led to a CBI investigation, they did not point fingers at any particular judge, and therefore would you not, at some level say that the Chief Justice was not personally involved in this? There was no finger pointed at him, and he was maybe in some right to say, look, I still hold on to my right and ability to determine which bench should hear which matter.
You see, though no judge is named in the FIR, in the CBI FIR, but the FIR does say that the entire conspiracy, preparation and planning was to bribe the judges of the Supreme Court who were hearing this matter. And throughout, there are about 8 orders passed by the Chief Justice in the case involving this particular medical college. So he was the one judge who was completely common. There were, in fact, amongst the 5 judges today, there were some other judges also who had passed orders in the case of this medical college. So strictly speaking, even they ought not to have heard this matter. But Chief Justice certainly ought not to have heard this matter, because clearly the CBI investigation will also investigate as to whether, or is supposed to investigate, and that is what is important, that in order to maintain public confidence in the integrity of the judiciary, this kind of investigation must be fairly, independently and thoroughly done.
What happens from here on, Mr. Bhushan? Does the matter get heard next week now? Which will be the bench that will hear the matter? Will there be any other way in which you can seek to achieve what you're seeking to achieve, which is to have an SIT be set up, an independent, fair-minded SIT?
I think this is something very, very serious that has happened. It's something which can shake public confidence in the judiciary enormously, and therefore it's a matter in which the entire country has a huge stake, because the judiciary is important for all of us. A proper, honest and independent judiciary is important for every citizen, and therefore the time has come for the citizens of this country, for other judges of the Supreme Court, for other senior advocates, etc., to take stock of what is happening and intervene in this matter and save the reputation, prestige, integrity and independence of the judiciary.
But what does that amount to, sir? Do you continue to agitate in this form? Will you continue with to press your writ petition for an SIT? What is the legal process from here onwards now, given that you haven't found the answers that you wanted from the Supreme Court, and the Chief Justice has said he will decide which bench hears it from here on?
Well, let us see. We have still not got a copy of the order that has been passed today. I am only speaking on the basis of what has been told to me by people who were there in the court after I had left. Let us see the order, and thereafter we will consider this matter coolly and take a call, discuss it with other people and take a call as to what is to be done.
All right, fair enough. Thank you very much, Mr. Bhushan. I appreciate you speaking with us today. Thank you for your time. That was Prashant Bhushan sharing with us an account of what has happened through the course of the week and today, which turned out to be a very tumultuous day in the Supreme Court. For an objective voice on what to make of the events of the day and the kind of light that it casts the Supreme Court in, I am joined now by Aman Lekhi, a very well-known lawyer in the Supreme Court. Mr. Lekhi, thank you very much for speaking with us. What are we to make of the events in the Supreme Court today? At the one level, this is a group of lawyers trying to seek the constitution of an SIT when it comes to some form of alleged judicial corruption. At the other level, it just seems that there was so much chaos and disarray.
Well, a lot of histrionics which actually courts the institution with a lot of obloquy. I don't think any of those involved have covered themselves in glory. Whatever has happened, extremely unfortunate, and no one has actually distinguished themselves, no matter how noble the cause may be claiming to plead. In the first place, I think it was inappropriate for two benches to hear the same matter, which is what happened because Justice Chalmeshwar and Justice Sikri were both hearing the same matter. It should not have been for the two benches separately, and it would behoove the parties to have intimated Chalmeshwar's bench about Justice Sikri also hearing the matter. One. Two, the law is very clear. If you want the judge to recuse, the application for recusal should be made specific to the judge concerned. So it was inappropriate for the lawyers to take a plea against Chief Justice for Justice Chalmeshwar, and it was inappropriate for Justice Chalmeshwar to actually consider that, because the appropriate step would have been to take the plea specifically before the Chief Justice, which was definitely an option which was available, because whether it's automatic recusal or a reasonable likelihood, this has to be so stated. It cannot be just a word orally as was done. Three, insofar as the Constitution, the bench is concerned, it is wrong because it cannot be denied that insofar as the prerogative is concerned, the prerogative is of the Chief Justice, and if we give and concede to individual judges the power to constitute benches, then there will be as many benches as there are judges, and then they complete anarchy in the court. So this is something which could have been avoided by referring the matter to the Chief Justice and leaving it to Chief Justice, so that the parties concerned could then have raised that issue before the Chief Justice specifically, saying the Chief Justice should not, for whatever reason they are saying, be part of the bench. before the matter came to the Chief Justice, and the Chief Justice constituted a five-judge bench different from the five-judge bench constituted by Justice Chalmeshwar. Now, this quite obviously makes a laughing stock of the Supreme Court because we have judges, individual judges constituting different five-judge benches depending upon their own disposition, which is an avoidable contingency where this is concerned. That said, however, there is precedent to show that when order is void, the order can be set aside in independent proceedings, which is, I presume, the reason why Justice Deepak Mishra set aside Justice Chalmeshwar's order, because Justice Chalmeshwar could not possibly have constituted that bench. That said, insofar as Justice Deepak Mishra himself is concerned, considering the issues you raised, apart from legality, which is obviously in the forefront of this particular issue, considering the apprehensions which were there, would have behoved the Chief Justice actually at that time by pointing out the illegality of what is being done, the inappropriate nature of the conduct which was self-evident, the regrettable presentation which is there of the lawyers in the different courts, which did not in any way distinguish either the lawyers as an institution, yet have actually said that because of whatever apprehension is there, he's got no personal stake or interest in the matter. There's no pressing commitment on his end to hear the matter. And if there's any issue, the issue should be raised specifically, will be dealt by him directly, so that if there are apprehensions, the apprehensions can be allayed. And if there's good cause for him to recuse, he should have recused. So whether it is the lawyers who are appearing on behalf of those seeking the SIT, whether it is Justice Chalmeshwar or whether it's just the Chief Justice, I do not think the manner in which the whole episode has unfolded has in any way added either the dignity or the repute of this constitution. On the contrary, I think it has dragged it down substantially.
Fair enough, Mr. Lekhi, but I must ask, you've explained to me many procedural complexities of how the Supreme Court is to be run and the protocols involved. My question is rather simple. Prashant Bhushan tells us that he thought it was only fit that the Chief Justice recuse himself from this matter, since the matter involved a series of cases that he had been hearing at one point in time, and there were these allegations of potential judicial corruption leading all the way up to the Supreme Court. Is that not a fair expectation? Is it just that procedure was not followed for that expectation to be met?
No, it's not a question of procedure alone. We have an organized system of law, and we've got a method in which an argument is presented and issues are raised. Prashant would have a legitimate cause of concern, but the legitimate cause of concern needs to be presented in a manner which is acceptable, so that there is no occasion for a judge to set aside that particular plea on a technical ground. But if you are sure about your position in law, at that point of time, it's only sensible to present it in a manner which is legally correct, so that it cannot be shot down on the ground. It's legally untenable. Insofar as justice the claim is concerned, that walks hand in hand with the legal tenability of it. And merely because you claim that your claim is just, you will disregard the legality of it, does not make sense. This is precisely what has happened. A technical point has actually been taken for the purpose of shooting down a particular plea, which may or may not be legitimate. And because that has been set aside for good cause, for which the legal precedent, whatever reaction there may be on the part of Mr. Prashant Bhushan or the others, which actually make us face this basic issue. Why is it that it was not done in a manner which would be appropriate? And the same thing could have been done by making an application telling the Chief Justice that he cannot hear that particular matter, and instead of raising the matter before Justice Chalmeshwar, raising it directly before the Chief Justice.
Okay.
It's not as if... Yeah.
Fair enough. But Ms. Lekhi, equally on the other hand, could it not have been that the Chief Justice could have stayed away from the matter without all of this procedure being met? Or do you believe that the Chief Justice did what he did by the book today, and said that no, please follow procedure?
No, I agree with you partially that is concerned. But see, it would have behoved the Chief Justice, considering the way in which this whole thing has transpired, after noting down all that has actually gone wrong, and it's really gone very badly wrong in the manner in which the whole thing has happened. It would have behoved him, after noting it down, pointing it to, in fact, have raised in stature, if he had, after noting down everything, pointing out the sorry plight of our affairs, the manner in which the lawyers have argued this matter, which robs proceedings of dignity, because there has to be some restraint in the presentation which you make in court. After setting all that out, it could have been appropriate for him to say that he is not in any way interested. He's got no interest in this particular matter, not keen to hear that particular matter, and is not for that reason very keen to be part of any bench hearing the matter. And his objection is the way in which his name is being tossed around in this particular manner. Suggestion of wrongdoing is being imputed to him behind his back. before judges where he's not, where such points cannot be raised. It would have been appropriate had that been done. But please understand, in the peculiar circumstances when benches are constituted, allegations are made. In that particular event, it may happen that the judge may, for that point of time, lose his cool and say, yes, this is something which ought not to have happened. But that apart, the Chief Justice has to actually stand above all this. In fact, he has to be the role model for all of us. He's the patriarch of the institution and actually the epitome of all the values we hold dear with the institution is concerned. And this was an ideal moment for him to actually stand out and stand apart after pointing out all that had gone wrong till that point of time and saying that whatever the accusation, however unfounded they may be, because he's got absolutely no interest in it. That would have put a closure to this and that would have embarrassed everyone else who's raising this particular issue. But unfortunately, and that's precisely what I have said, no one has actually quoted himself as glory in this particular matter because the way in which is being presented, no matter what the merit of what is being presented is concerned, robs whatever is being said of any value whatsoever.
Fair enough, sir. I have one final question. Is there any way to know what happens here on? I know that the Supreme Court, the Chief Justice today said in Supreme Court that the matter will be heard 2 weeks hence. Do you believe that it should be heard by another bench, that all of this procedure must be followed, and then the Chief Justice recuses himself? So if you can give us any idea of how this should proceed from here.
Once we have an organized system of law, I mean, I'm a purist where this is concerned, and I do not think that being a purist brings in any technicality of this concerned, because technicality and substantive aspects of law go together. I personally think there are adequate avenues available to anyone well informed in the law to take appropriate steps in that direction to, in fact, ensure that if there is reasonable ground to believe the Chief Justice is in any way disqualified from hearing, that he should not be part of any particular bench. But instead of hurling accusations and walking out of court in a huff, it is better that proceedings are actually presented and pursued with some element, with modicum of sense and propriety, so that the issue can actually reach a conclusion which is legally warranted. And there's adequate provision in law to ensure if there's cause for Chief Justice not to be part of this bench, to ensure that he's not part of any future bench which has a particular matter.
All right. And one final very short question to you, sir. Through the course of this year and last, we've seen several incidents cast the Supreme Court in poor light. I will not go into the details of all of them. But what worries me, and that really is my big worry about what's gone on today as well, is that all of this plays into the debate on whether judges should be politically elected or elected by the collegium, and the big face-off that we've witnessed between the Supreme Court and the attempts by the legislature to put in an NJAC. Do you think these events are all going to culminate in some big change of some sort finally?
No, this debate insofar as the method for appointment is concerned is, in this particular issue, I think extraneous and irrelevant, because no matter how the person is appointed, insofar as the judges are concerned, the way in which they have to act is something which will have necessarily to be followed no matter what is the method in which they've been appointed. Yes, this brings into focus the fact that there's something drastically wrong with our system which requires some particular correction. But what is wrong with the system has got something to do with our temperament and character. And we as a nation are very argumentative and emotionally charged. And because we are too argumentative and emotionally charged in law, as far as the courtroom is concerned, the courtroom requires a bit of restraint and balance so the presentation is concerned. If we lose that balance and restraint, the whole purpose of having a legal system will actually go down the drain, because it is merely to curb these kinds of behavior that law is there in the first place. So it is not as if it's the judges who are at fault here also. The lawyers are at fault too. So it's not, I don't think it's appropriate only to blame the judges. In this particular case, as I said in the beginning, everyone who's involved has actually portrayed themselves in just clear infamy in bringing a very serious issue into utter ridicule by the way in which they have dealt with this particular matter.
I'll let that be the last word on this conversation, sir. Thank you very much for joining us this evening. Aman Lekhi there, giving you his perspective on the events that took place in the Supreme Court today.